According to us, it is really unfair to have this continuing on the statute book because it's not just a one-time issue. It's an abiding impact which continues across generations. Now I come to my next point because I understood a submission to be made that with regard to culture, there has been no explanation in either the pleadings or in any of our documents as to what it is, etc. So I'm just giving you the paragraph numbers and the page numbers, and I'll just summarize our case. In writ petition 876 of 2014, which your lordship will find at volume 3, the averments as far as culture are concerned in great detail are from paragraphs 21 to 34 of the petition. Yeah.
Persons who would have not been included, but still it open to them to contend that we were there before 66.
Yeah. So I'll just answer.
Actually, that's also possible.
Yeah. The question to being, as I understand it, is that is it too late in the day to provide a machinery insofar as 682 is concerned? That's one, I think, one part of the question. In my respectful submission at this distance of time, which is 37, 38 years after 1985, that's why we waited to see how are they going to place their case as far as machinery, etc. is concerned. But nobody even suggests that there's a machinery under 682.
Actually,
so I would, sorry.
There's a little bit of a policy determination by Parliament. I think what Parliament seems to have done was that they said prior to 1966, they gave a very liberalized regime for deeming citizenship. After 66 and
it's the same four criteria.
But between 60, you're right, same criteria.
Same criteria.
But with the addition for 66 to 71 of registration. No registration.
But that's included, Manoj. That's, please see that.
There is no registration requirement for prior to 66.
Sorry? Registration under 63. Yes.
So, therefore, for those who came in between 66 to 71, they had one specific criterion, namely that you must have been detected as a foreigner. That is, it's like an amnesty. That, first you are detected as a foreigner. If you are not detected as a foreigner, you don't get the benefit. After you're detected as a foreigner, you have to then register. If you have registered, then you get citizenship. That's the scheme for 66 to 70.
That is how we understand it as well.
That's right.
Because it was suggested, and just to add to that, we didn't find any method by which you can make a self-declaration.
You have to be detected.
It has to be detected.
Now, prior to 66, I think there seems to be some sort of a more, should we say, a more relaxed regime which was applied by Parliament.
What does it mean?
On the basis that, these were things which happened in the past. They are not going to go out of India. You don't want them to be stateless. They have assimilated for all intents and purposes, because prior to 66 means that 19 years had elapsed even when the law was brought into force. Parliament felt that, all right, now what has happened in the past, let's now freeze it at that.
Well, I would respectfully submit. So just responding to the point, I would be a little more generous to Parliament. In the sense, I would suggest that Parliament is certainly providing criteria which are objective. So what I'm suggesting to the court is that I believe it would be correct to interpret this statute as saying that Parliament intended exactly what it mentioned. It didn't want to just hand over citizenships XYZ.
There are those conditions even there.
There are criteria which are there. Now, if you have criteria which are there ought to be a machinery. So what your lordship is saying, there's not even a census. It's not even after this act comes into force that there is a count that at least we are freezing everybody on this day.
There would be
not even that.
There would be a machinery under the foreigner's order.
No, there's nothing, my lord. Nothing happened after 1985. We specify so that nobody can really object and say it's criteria less. And then we have no machinery, so it becomes criteria less. And then there's a distance of time, so therefore an argument is advanced that delay and later. So I think we should be. So I've done with that. Now, my lord, yes, no. So I'm just making the point. So now on culture, I was on that aspect. Culture. I've given you the pages where we have detailed, we've cited, my lord, various international covenants, etc., with regard to the protection of culture, and based on the census report, because the studies which we placed in our opening were based on the census figures. So 4 impacts: language, religion, land holding, and number 4, self-governance. Because if you're taking away vote, it's a right according to our self-governance. Organizing yourself in a community is all a very, very important aspect of culture. And what is happening here is there is an enormous undermining of the local community by, I will use the expression, non-citizens. So that's the cultural impact which we have, which we believe we have been able to satisfactorily project. None of this has been contested at all. Now I come on to the point, next point, which is with regard to proportionality and the basket of rights. Now, citizenship, as we understand it, I indicated that earlier, is a full-fledged basket of rights recognized under the Constitution, recognized under statutes. One can understand, there are subordinate rights. Those subordinate rights might involve an exclusion of political rights. It might involve an exclusion of certain economic rights.
What is that point? Subordination?
Sorry?
What is the second point?
No, so I'm just suggesting to the court that you have a full basket of rights.
Yes,
That's one. That's citizenship. But there can be situations. So, for example, let me just give you an example. International humanitarian law requires, there are minimum standards under international humanitarian law. You have to provide that. You can't, but that is short insofar as of citizenship. So, the proportionate response which would be in a situation such as this, if people have come from 1966 or earlier than 66, or because of certain situations and exigencies, such as facing deprivation or facing much more hostile circumstances, then certain minimum international human rights, humanitarian law standards can certainly and ought to be extended. But that is short of citizenship. And therefore, in our respectful submission, 6A fails to narrowly tailor benefits to non-citizens. It is completely disproportionate in what it grants and gives without any meaningful scrutiny. And so the expression used, live and let live, is perhaps consistent with international humanitarian law in the context of illegal migrants, but there is no requirement of conferring citizenship. That is something much higher. And this provision, in doing so, perhaps exceeds permissible limits. Now I go to my next point. So I will just come to statelessness, but just have a look at one provision which was read, which is the Foreigners Act. Sorry, but there are two sections I want to read. First, please just have a look at the Foreigners Act. Section 3. So I'm going to just read this, just read the section. So your lordships will see what can the central government do, or what is it required to do elsewhere in the country. Your lordships have Foreigners Act 1946.
Yes.
So if we see section 3, directly I'll just read this. 3.1, power to make orders. The central government may by order make provision, either generally or in respect to all foreigners, or with respect to any particular foreigner, or any prescribed class or description of foreigner, for prohibiting, regulating, or restricting the entry of foreigners into India, or their departure therefrom, or the presence of continued presence therein. In particular, and without prejudice to the generality of the foregoing power, orders may be made under this section that may provide that the foreigner, A, shall not enter India, or shall enter India only at such times and by such routes. B, shall not depart from India, or shall depart only at such time and by such route from such port. Shall not remain in India or in any prescribed areas therein. Shall, if he has been required by order under this section not to remain in India, meet from any resources at his disposal the cost of removal from India. D, shall remove himself to and remain in such area in India as may be prescribed. Shall comply with the conditions as may be prescribed or specified, requiring him to reside in a particular place, imposing any restrictions on his movement, requiring him to furnish such proof of his identity and to report to such particulars to such authority, requiring him to allow his photograph and finger impressions to be taken, requiring him to submit himself to such medical examination, prohibiting him from association with persons, prohibiting him from engaging in activities of a prescribed or specified description, prohibiting him from using or possessing described or specified articles, otherwise regulating the conduct in any particulars as may be prescribed, shall enter into a bond, etc., shall be arrested and detained or confined, and may make provisions for any matter which is or may be prescribed, and for such incidental and supplementary matters. So very wide. Now, this is the regime which applies across India for foreigners. This is their power which they have. And please see subsection 3, any authority prescribed in this behalf may, with respect to any particular foreigner, make orders under clauses E, F of subsection 2, which, as your lordships have seen, includes the removal, requiring a person to reside in a particular place, etc., and to enter into a bond, etc. So now this is the national regime. So they have these powers. And I think the purpose of this section is also to draw the distinction between citizens on the one hand and foreigners on the other hand. So there's a divide, and there is a huge gap, therefore, in lifting up to a citizen. Now, please see the other provision which was read to your lordships is the Immigrants Expulsion from Assam Act 1950. Now, look at this statute. It's at page 424 of volume 4, and it's at serial number 10. Same volume. Now, see the parliamentary mandate here. So I'll just make 2 or 3 submissions. First, where the expression in section 2 is the central government may by order direct the person to remove himself, we would respectfully submit this is a power coupled with duty. That's one point I want to make. So the whole emphasis is that you have a parliamentary statute which is extant for expulsion of people from here. And on the same hand, how do you balance that with section 6A and this open-ended no time limit provision which continues to act as a beacon? So the two really don't stay or can't really sit side by side. And here, if we are correct that this is the act which really should be worked and its main purpose is expulsion, then I would respectfully submit that as far as the proviso is concerned, it has to be given its plain meaning, but it's a narrow exception to the general rule. It's a narrow exception insofar as the general rule is concerned. Yes, and this again, my lords, there's no question, of course, here of conferral of any citizenship.